It's my it's my great pleasure to introduce Kieran Tapsell. Kieran studied for the Catholic priesthood at Columbus College in Springwood and St. Patrick's College, Manly, from 62 to 67. And after leaving the seminary, he studied law at Sydney Uni. He was admitted as a solicitor and barrister of the Supreme Court of New South Wales in 1973 and practiced mainly in commercial litigation. The first edition of Potiphar's Wife, The Vatican Secret and Child Sexual Abuse, was published in 2014. It formed the basis of his submission to the Royal Commission into institutional abuse, institutional responses to child sexual abuse. Canon law, a systematic factor in child sexual abuse in the Catholic Church. The second edition of the book was published in December 2024 and is available in ebook and printed form from Amazon. It deals with developments since 2014, including the 2017 final report of the Royal Commission and 12 other inquiries since 2017. Kieran is the author of 78 articles on the subject of canon law and child sexual abuse, published in the Journal of the Australian Catholic Historical Society, the Journal of the Academic Study of Religion, the Sydney Morning Herald, La Crosse International, the National Catholic Reporter, The Guardian, El Espectador at Columbia, Eureka Street, The Swag, and Pills and Irritations. Kieran, my great pleasure to introduce you, sir. The floor is yours.
Thank you, Murray. The topic of my talk today is, in fact, the subject of this whole conference, and that is the concept of zero tolerance. The term zero tolerance was first used in political discourse in the United States in 1972, and it referred to the strict enforcement of the law. Merriam-Webster defines zero tolerance as, quote, a policy of giving the most severe punishment possible to every person who commits a crime. The policy has its critics because it does not take into account that offences may vary in their seriousness and the circumstances of the offender might justify a lesser sentence. In civil law, however, which has the proportionality system, there is often zero tolerance in practice. It was drummed into us, lawyers, in the ethics courses at university, that if as a lawyer you use trust account money for your own advantage, you will be struck off the rolls permanently. And in my 40 years' experience in New South Wales, I have never heard of a solicitor being readmitted to the rolls after such an offence. That's zero tolerance. In an address in 2002, Pope John Paul II said, "There is no place in the priesthood and religious life for those who would harm the young." The Australian Royal Commission into Institutional Responses to Child Sexual Abuse in this 2017 final report quoted those words of the Pope when it said that the appropriate punishment for child sexual abuse was dismissal from the priesthood and expulsion from the religious community. And that happens to be the maximum punishment under canon law. Now, since his election in 2013, Pope Francis has publicly claimed 8 times that the Church practices zero tolerance of child sexual abuse by clergy and religious. That claim is simply not true. On the 17th of January 2014, Archbishop Tomasi told the United Nations Committee for the Rights of the Child that since 2005, more than 3,400 credible allegations of sexual abuse of minors had been referred to the Dicastery for the Doctrine of the Faith, that used to be called the Congregation for the Doctrine of the Faith. As a result, 848 clerics had been dismissed and other disciplinary measures had been applied in 2,552 other cases. That's not zero tolerance. It is 75% tolerance. We do not have any statistics for dismissals or otherwise since 2014 because the Vatican will not publish them. In 2014, the same year, Archbishop Coleridge of Brisbane told the Australian Royal Commission that he had sent applications for dismissal to the DDF in respect of 6 priests who had been convicted of sexual offences in the Australian criminal courts. The DDF rejected 5 out of the 6 applications for dismissal. That's 83% tolerance, not zero. An Indian priest, Joseph Jayapal, pleaded guilty to the sexual abuse of a 14-year-old girl while serving as a priest in Minnesota in 2004. When he returned to India, he was reinstated to active ministry after the Bishop of Uttarakhand petitioned the Vatican for authorization. He got it. That's not zero tolerance. In 2019, Father Hilary Ngome in Cameroon, according to Bishop Accountability, continually raped a 13-year-old girl. His public ministry was restricted pending canonical proceedings. On the 15th of August 2022, Bishop Beebe wrote to the faithful explaining that the DDF considered that the 14-month suspension was sufficient. Ngome was restored to full ministry. That's not zero tolerance. In 2014, Brother Crow, the provincial of the Marist brothers, told the Royal Commission that not one of the 16 Marist brothers convicted in Australia for child sexual abuse had been expelled from the Institute because the Roman Curia had told them that expulsion from the Religious Institute was not possible if the limitation period had expired or if they had not been given prior canonical warnings. That's 100% tolerance, not zero. Brother Crow tried to justify the return of these brothers to the religious community on the grounds that they would be supervised after release from jail. These teaching orders almost invariably have their monasteries near their schools. It is a bit like saying to an alcoholic after release from jail, come back to live at the pub and we will make sure you don't have another drink. Brother Ambrose Payne of the De La Salle brothers told the Royal Commission that supervising such people was, and I quote, an extremely difficult practical managerial operation. The Royal Commission said they could still be expelled from the community and the brothers could still supervise them if they wanted to support them in some ways by having some conditions attached to their financial or other assistance. Pope Francis is not the only one in the Vatican to use the term zero tolerance. The 2024 Universal Guidelines for National Protocols issued by the Pontifical Commission for the Protection of Minors states 3 times that zero tolerance should be the policy for child sexual abuse. And it defines zero tolerance not as dismissal, but something close enough to it, as requiring permanent removal from ministry. But then clause 4.2.12 of the guidelines says that where someone is convicted of a canonical offence of child sexual abuse, the punishment imposed by the DDF is to be followed. Canon 1398 of the new Book 6 of the 1983 Code provides that if a cleric, religious or layperson sexually abuses a minor, they are to be punished with deprivation of office and with other just penalties, not excluding where the case calls for it, dismissal from the clerical state or expulsion from the religious order. Canon 1398 does not require permanent removal from ministry, so long as there was a deprivation of office or other just penalties. A removal from ministry could be a few days, a few weeks, or 14 months, as in the case of Father Ngome, or none at all. The claims about zero tolerance are yet another example of bella figura that pervades the Vatican. Bishop Geoffrey Robinson explained that in Italian culture, bella figura, literally a beautiful figure, means presenting a good external appearance to the world, while brutta figura, literally ugly figure, means doing the opposite. The culture of bella figura requires never admitting a mistake and then trying to cover up that mistake. To get around Pope Francis's claims of zero tolerance, the Universal Guidelines reduces the term zero tolerance to gobbledygook. They say that any priest found to have sexually abused a child will be permanently removed from ministry, but if the DDF decides otherwise, then he won't be. Another way of applying bella figura, covering up a mistake, Pope Francis's mistake in using the term zero tolerance, is to do a Humpty Dumpty on it. Remember in Alice in Wonderland, Humpty Dumpty said words will mean what I want them to mean. It depends who is in charge. In 2023, one canon lawyer did just that by saying, you have to understand what zero tolerance means. It means the complete condemnation of child sexual abuse, but then making the punishment fit the crime. That is not zero tolerance. The Vatican, however, does practice zero tolerance when it suits them. Priests who want to marry in the church have to apply for a dispensation from the promise of celibacy, and in return, they are required to be laicized. There have been many priests who wanted to marry in the church. In my seminary class, for example, half of the 22 ordained left the priesthood within 10 years to marry. Laicization is also the church's highest punishment for child sexual abuse. Priests who have been permanently removed from ministry but not dismissed can say Mass privately, and in some cases have been allowed to concelebrate Mass at the funerals of their parents. No priest who wants to marry is allowed to say Mass privately at home or to concelebrate a requiem Mass for a parent or even his wife. If laicization is mandatory for priests who have never sexually abused a child and want to marry, surely it should be mandatory for those who sexually abuse children. The Universal Guidelines have another problem. They say that zero tolerance is to be applied, and I quote, within the local cultural context. What on earth does that mean? It raises the question if child sexual abuse should be more tolerated in some cultures, and does that mean less strict punishments for abusers? The Ngome case I mentioned before in Cameroon illustrates the problem. A 2023 UNICEF report highlights widespread sexual exploitation of children in Cameroon. We don't know if the cultural context of child sexual exploitation in Cameroon influenced the decision to restore Ngome to ministry, because the DDF does not publish its reasons. The case of Bishop Bello in Timor-Leste is perhaps another example. Bishop Bello was the joint recipient of the Nobel Peace Prize for 1996 for his role in the Timor-Leste independence struggle. In 2022, a Dutch newspaper accused Bello of multiple sexual assaults on young boys in the 1980s. The Vatican must have accepted the truth of this because it discreetly moved him to Mozambique and then to Portugal and restricted his contact with minors. In a late line program on Australian television, a Timorese anthropologist said, "A lot of people do not understand the issue of pedophilia in Timor-Leste. It's not like the West, in Australia and the UK. If you are a pedophile, it's, really bad." In contrast to Bello's punishment was the dismissal from the priesthood of an American missionary in Timor-Leste. Father Richard Dashbach, who admitted multiple offences against young girls, was subsequently given a 12-year jail sentence by a Timor-Leste court, but he was also dismissed by the Vatican. Was the vastly different canonical sentence imposed on the Timorese Bishop Bello because of his Timorese, quote, cultural context? And did that not apply to the American priest because he was not Timorese? Well, we'll never know, while the Vatican does not publish its reasons for its decisions in disciplinary matters. However, if this was a reason, it shows an extraordinary contradiction for the Church that has railed against the dictatorship of relativism in Western secular society. The Royal Commission recommended changes to the Church's disciplinary system, particularly Canon 1321 on imputability, the Church's equivalent of a defence of insanity or diminished responsibility in civil law. The Roman Rota interpreted Canon 1321 in such a way as to create a catch-22 defence for the abuser priest. He cannot be dismissed for pedophilia because he's a pedophile. In 1994, Ireland's worst clerical sexual abuser, Father Tony Walsh, was dismissed by a Dublin canonical court. The Rota allowed his appeal because he'd been diagnosed as a pedophile. In 1999, the same decision was reached in the face of Father Patrick Maguire, another serial abuser. In 2004, the Review Board of the United States Conference of Catholic Bishops observed that because of Canon 1321, the worst predators were the most difficult to dismiss. The Royal Commission's recommendation 1613 is that canon law be changed so that a diagnosis of paedophilia is not relevant to the prosecution of or a penalty for the canonical offence relating to child sexual abuse. In 2002-1, the revision of Book 6 of the Code, in that revision, the Vatican did not change the language of the Latin wording of Canon 1321. A canon lawyer, Dr. Peter Akpogiran, published a textbook in 2020 called Canon Law Evidence in Penal Cases. And it's not surprising that in his discussion about Canon 1321, he repeated the interpretation that was reflected in the Walsh and Maguire cases and the comment of the US Review Board. While canon lawyers have case law guidance for annulment of marriage, they have virtually none for child sexual abuse. No one knows if the Rota still applies the catch-22 defence, since its decisions are not published. Kurt Martins, Professor of Canon Law at the Catholic University of America, said in 2023, this lack of systematic publication of the jurisprudence of the highest courts in the Church is unworthy of a true legal system. And this is a damning criticism of canon law, which some canon lawyers claim, and with some justification, is the oldest continuing legal system in the world. The continuous claims of Pope Francis that the Vatican practices zero tolerance for child sexual abuse is just another example of bella figura. It isn't true. If Pope Francis wants to exercise leniency, then he should stop using the term zero tolerance and admit that it was never appropriate for him to use that term. The rules of bella figura, as I mentioned, require that a mistake is never admitted. However, Pope Francis is capable of admitting mistakes, as he did in 2018, when he admitted he was wrong in the way he accused the Chilean victims of sexual abuse of slander. But if he doesn't recognise that zero tolerance is an inappropriate term to describe the way the Church deals with child sexual abusers, then he will be adding more evidence and more fuel to the fire of the claim by Jason Berry, a committed Catholic and one of the first to write about the sex abuse scandal, that the Church hierarchy is plagued by institutional lying. Thank you.
Thank you, Kieran. Just on Canon Law 1321, do you agree with critics that Canon Law 1321 is itself a damning criticism of canon law itself?
Well, the thing about 1321 is that, and they haven't changed it in the new Book 6, is that it is capable of being interpreted in a way which does not create this catch-22. The problem is that the Rota has interpreted that way, and there is no evidence whatsoever that any of the canonical courts or the Vatican thinks differently. And the reason I actually mentioned that canon lawyer's book is because that's exactly what you would expect to happen. Because lawyers, whether they're canon or civil, are like bookmakers in a way. They tell you how cases are going to run in court.
Mm.
And that's why, as Kurt Martin says, you have to have publication of cases. And this is exactly what the Australian Royal Commission has said. The more recent French, I think it's called the CAS report, said exactly the same thing. If you want a different interpretation put on these things, you must publish the cases. But no one knows whether or not the Rota is still applying that, and you can't blame canon lawyers advising bishops whether or not they can proceed against a serial pedophile, to say, well, look, for all we know, the Rota is still saying the same thing.
Right. So for those not expert in Vatican politics and Vatican structures, can you explain the Rota, please, Kieran?
Sorry, yes, the Roman Rota is a court of the Vatican. And for example, annulment cases will generally go to the Rota. And if you look at canon law journals, such as the Canonist, the Australian New Zealand Journal of Canon Law, it's a bit like the Australian Law Journal for Civil Law. You'll have learned articles at the front, and at the back you'll have High Court reports. And there you'll find annulment cases, lots of them, to guide canon lawyers advising people about annulments of their marriages. There's nothing there about child sexual abuse. Not so far.
All right. So to wrap up, in a word or in a sentence or two, would you like to give a pithy statement about your attitude to the notion of zero tolerance?
Well, zero tolerance is exactly what the Royal Commission recommended. If you abuse a child, and it doesn't matter how serious it is, or you should be dismissed if you're a priest and expelled from your community, religious community, if you're not. There should be no question about. As I said, in civil law, you do have things like that. There are certain things. Another example would be if you kill someone, at least in my state, while you're drunk driving, you go to jail. No exceptions. You go to jail. And that's not because it's written in the law of zero tolerance. It's just that's what the judges regard as being the appropriate sentence.
Right.
And that's what the Royal Commission said was appropriate sentence. And ironically, that's what Pope John Paul II said was the appropriate sentence. But they're not practicing it.
Kieran, absolute pleasure. Thank you, sir. We're in your debt. Your contribution to this summit in the Philippines was immense, and we value it. And thank you, sir, for your presence at this summit.
Thank you, Murray. Thank you.